Hello, New Hampshire Realtors. This is Joni McIntyre, your 2024 president, and I'm here today with legal counsel Matt Johnson to discuss the NAR settlement that was proposed on Friday. Hi, Matt.
Hi, thanks for having me.
So first, this is a proposed settlement. Can you explain that to us?
Absolutely. So yes, it is a preliminary settlement reached by the parties, but this is a class action lawsuit and it seeks to enter into a settlement nationwide. It has to go in front of the federal judge for approval, and there actually has to be a motion filed asking for approval, none of which has happened, and realistically probably doesn't happen for 2 to 3 months at the earliest. So this is very much still preliminary and not approved.
So right now, what you're saying is we haven't changed in any way right now.
Correct. Putting aside all the press releases and articles you might have seen on your phone or in the paper, nothing has changed, and there is no requirements for realtors to presently change any of their conduct. This is just putting everybody on notice that changes may be coming.
Okay. So can you tell us what's in the settlement?
Sure. So NAR tried to find a global resolution to the litigation it had around the country. And so what this does is it tries to resolve as much as possible all of the remaining litigation nationwide. NAR has obtained a release for itself, its member boards, both state and local, and members of individual independent contractors who are members of NAR, with a couple of exceptions. The primary one is Home Services, and its agents are not a part of this preliminary settlement agreement.
That's great. So the corporations who've already settled, they're released as well.
Yes, this is all part and parcel of the same thing. So their settlement, I don't know how they'll do it, but their settlements are going to be part of the overall settlement. And so Anywhere agents or Remax agents or Keller Williams agents, they have the same protections that they did before. Nothing changes with that settlement, their settlement agreements.
Okay. And next, there's a change in compensation rules.
Yes.
That's proposed.
As proposed, will be no ability to put an offer of compensation on an MLS or do anything to sort of aggregate that data in a different way and make it public. And so that it has to be off of the MLS. Importantly, it doesn't mean that a seller can't offer compensation, but it just cannot be through the MLS. It needs to be in discussions with the listing agent and on a more individualized basis. It also doesn't mean that sellers can't agree to pay buyer concessions such as closing costs, so none of that changes. It's really just the vehicle or the manner in which such information is presented to buyers and sellers.
Great. That's great. Next, a written buyer agency agreement. That seems like a easy one for us here in the state of New Hampshire.
Yes, one of the key components of what NAR agreed to do was require all buyers to enter into written buyer agency agreements with their buyer agent customers. Good thing for New Hampshire that as a matter of statute and real estate commission regulations, we already require that. We already have form buyer agency agreements. So for us and in New Hampshire, that is not a significant change. It is a more significant change in other parts of the country where there is no history of using written agreements for buyer agency.
Great. So we're ahead of the curve on that. Next, there was a settlement amount that was offered.
Yes. So NAR has agreed to pay $418 million over a period of 4 years as a means to resolve all of the lawsuits and include within it the member boards, the state associations, the local associations. Any of the realtor-owned MLSs are also in it. And also, I would point out that any brokerage that has less than $2 billion in total transaction volume in 2022 and had a realtor, had their principal be a member of NAR, is also protected by the settlement agreement. And in fact, even brokerages that are over $2 billion, there's a mechanism for them, that brokerage firm, to opt into the settlement. So there's really a goal to try to get back to buying and selling homes and not be involved in nationwide litigation.
Okay, so that's great news about getting back to buying and selling. I guess the final piece is that the no wrongdoing.
Yes. As you would see in most settlement agreements, NAR has not admitted to liability. They have expressly indicated they do not admit to liability. They preserve all of their defenses, but for practical reasons and efficiency reasons, they agreed with the plaintiffs to settle the case, which is a very, very common result in litigation, particularly high-risk, complex litigation. It is far more likely that the parties reach a settlement agreement than they actually go to trial on the many cases. So it's not a surprising result to see that the parties reached a settlement agreement.
Great. So this is just proposed, as we said in the beginning. The court has to approve it.
It does. And so the important timeline is right now NAR is estimating that if changes that we talked about were to go into effect, they probably don't go into effect until July 2024. I would say, as a lawyer, that's probably optimistic, frankly, because this is going to be a lot of process to get this agreement approved, and typically it always takes longer than what everybody thinks. So I suspect those changes, if they're going to come down the pike, if the settlement is approved, you probably no sooner than the summer, and I'm going to guess more realistically the fall of 2024. But again, that's my guess, just given the complexity of what the parties have agreed to.
Okay, that's great. And to circle back, the two things that really affect our realtors in this state, first is the compensation piece, and we don't really know how that will shake out until it's approved.
Correct. And it doesn't change New Hampshire law and in the compensation piece. I want to be clear about that. There have always been different ways for buyers to pay their buyer agent. There can be flat fee arrangements. There can be percentage arrangements. They can get a percentage of the commission from the listing agent. All of those things are still viable. All of those things are still going to be available. Really, it's changing how those payments are negotiated and the mechanism for that. So there's no changes required in New Hampshire law. There's not a new compensation model. You may just see more variety of compensation models moving forward.
And the second thing that I think is as important is the buyer agency agreement, which we already do in the state, and hopefully people are going over that with their clients, going through that whole agreement.
Yes, and I would just reiterate for our agents that the buyer agency agreement form that we have already commits the buyer themselves contractually to pay a fee to the buyer's agent. So we already established that. The market doesn't always work like that in terms of the source of where the money comes from, but legally we already have that in the form, and I would encourage all buyer's agents to make sure they're familiar with that and work on their explanation to the buyer agents as to what their services are, why they should be compensated or a fee, what value they're providing, because that's going to be the discussion they should be having now and most certainly will have to have with their buyer clients if this preliminary settlement agreement is approved.
Okay, I think that's all. Matt, thank you so much. You'll be hearing more from us on this, I'm sure, as we move forward. And if you have any questions, please don't hesitate to reach out to our office here on Main Street in Concord.
Thank you, Joni.
Thank you.